Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Hello, and thank you for joining the Jury Thinks What, a podcast by trial lawyers for trial lawyers. I am Saul Gruber from Gruber Trial Consulting, your host. And today I'm pretty excited about guests that we have. They are the nursing home law firm in Atlanta, Georgia, with verdicts after verdict after verdict. And when I say they, it's because we're having three members of the firm, of the Prieto law firm, Mike Prieto, Jon Marigliano, and Bill Holbert. And they're going to talk to us at length about their last verdict, why they think they achieved a good verdict, and how they went about it. And again, this will be a nursing home case. This is Saul Gruber from Gruber Trial Consulting, and this is The Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. You can subscribe to this anywhere you get podcasts. And I also ask you to look to the Gruber Trial Consulting YouTube channel, where we give our weekly trial tips as well as our weekly nursing home minute. Now let's get to the guests. Okay, and we are back. This is The Jury Thinks What, and I am Saul Gruber from Gruber Trial Consulting, your host. And as you all know, this is a trial lawyer podcast by trial lawyers for trial lawyers, with the purpose is to help lawyers all over the country understand not just how they're doing things, but why they're doing things. And one of the things we do in this podcast is bring in lawyers from the front lines, not just people who write books and talk about trying cases, but people who are actually trying cases and getting verdicts. And today we have two good friends of mine, which doesn't happen too often in the podcast. So that's kind of nice. We have Mike Prieto and Jon Marigliano from Atlanta, Georgia. And I would say, Mike, you would agree with me. You guys have the preeminent nursing home neglect firm in the state of Georgia.
I certainly tell all of our clients that we do during the sign-up process. We certainly have the largest volume of cases, and you can't discount lawyers in Georgia like Lance Laurie and Stephen Chance and Jeff Helms, who are also fantastic trial lawyers. Evan Jones.
I was going to say, if you didn't throw Evan in that, I would get in trouble.
And Dan Cotter, who led the way and was one of the first folks in Georgia to do long-term care. We've been very blessed in our practice. Unlike some of the other firms that I mentioned, we are probably 98% long-term care based, with a sprinkle of personal injury and medical malpractice.
And Mike, you and I, of course, have known each other for an awfully long time, which is nice. And I got to know Jon a lot over the last few years in working with you guys. So I'm really excited to have both of you on. I want to thank you for coming on today. One of the things that we talk about a lot on these podcasts are trials. And there's a lot of trial lawyers out there who don't try cases. And we're aiming not to have those people on as guests. We're kind of trying to bring people on who are actually trying the cases. And I remember, I think it was last year, you guys were involved in a trial in Atlanta, the Mitchell case. Was it last year or 2 years ago?
It was April of 19. Yeah, 19.
It seems to me that the pandemic has screwed up all of my ability to understand years. But why don't you tell us a little bit about that trial, what it was about, and then let's get into the specifics of it for our audience.
Okay. Well, Miss Mitchell, who was a wonderful lady who had two sons, and her sons were a wonderful one. They made a wonderful family. She had a great story. We got to learn a lot about her life, how she raised her two sons as a beautician, as a single parent. And so you know as well as I do that the family makes the case. And here, the family decided that they would go to a facility that was closer in proximity to ensure that they could remain very active in mom's life over some that may have been, held in higher esteem that were further apart. So they were there every day. And if you want to know how to start a case for a trial, you find families that remain active in their loved one's life.
It's funny that you say that. David Hoey tells I don't know where he stole the mantra from. I'm confident that David, and we both know David very well, didn't come up with this on his own, but he said he needs three things to take a nursing home case. He needs a really good family, a really bad facility, and a horrific injury or act. He said if one of those three aren't there, he doesn't want to take the case. And when he violates that rule, it normally bites them in the you-know-what later on.
God bless him, because I can't say we have the majority of cases that satisfy all three.
But what you're saying is right. You have to have a really good family for the story.
I think it all starts and ends with the family. We had a great family. And I think the jury found that this family was very involved. Miss Mitchell was, in all candor, in an end-of-life scenario. She had been declining. She was non-communicative or barely communicative. And there was an occupied bed change. There was a dispute as to whether it should have been a one-person or a two-person. But regardless of whether it was one or two, you're not supposed to roll someone out of bed and let them hit their head on the ground, which is what occurred here. She had a subdural hematoma that probably resolved itself. She passed about 30 days later. It's interesting, like many of these cases, we see the death certificate that doesn't mention it whatsoever as a contributing factor to death. And so that set the basis of our claim. The case was litigated with our good friend, Evan Jones, and it's, the long-term care world is a little bit different than what we see in other areas of the law. The gentleman wasn't happy with an original lawyer who didn't do long-term care work, had met with Evan, unbeknownst to me, came to meet with me afterwards. And I will never let Evan live down the fact that before he left my office, he said, "Oh, I want you guys." So I'd asked, well, who else did you meet with? And he said, well, I met with Evan. And I immediately picked up the phone and called Evan and told him. And very graciously, Evan said, "Mike, no big deal, take the case." And immediately I said, "No, Evan, let's work the case together," because we always look for opportunities to work with our friends. And so Evan and Bill Holbert, who's not here, John and I worked the case up. It is a case that I still don't understand the defense.
Let me back up just for a second. And we did the same thing in New Jersey. I mean, if someone was trying to pick between David Cohen and me, or Michael Ringgold and me, we would call each other and decide, let's do it together. That way, everybody's involved, and there's nothing more fun than trying a case or handling a case with a friend of yours. And it's incredible how much you learn.
Absolutely.
That you normally wouldn't, just because we're such good friends. We may not get too involved in law. We're talking more about, for us, it was the Eagles. For you guys, it may be the Braves. But yeah,
the Falcons.
Well, it can't be the Falcons.
It can't be the Falcons.
No, it can't be the Falcons.
It's
not from what I've been seeing. But I want to make sure I have this case right. You have an elderly woman who needs help just getting out of bed, who's on hospice, and somehow it's supposed to be a one or two person transfer. She ends up falling and getting a brain bleed that resolves itself. And when she dies, the brain bleed is not on the death certificate.
There was actually notations that the defense relied on heavily in the medical record at the hospital, and to some degree at hospice afterwards, that showed she had actually rebounded cognitively. And so the defense, as they should have, made a big deal about that, try to poo-poo the liability, make this a causation case, and just said, listen, we gave her a bleed, but it resolved. It's not a wrongful death.
So in the personal injury world, people would look at that case and turn it down.
Absolutely.
They would look at that case and say, well, that's unfortunate, but she got better, and her getting better is still really bad, so we're not going to take the case. But in the nursing home world, which I come from, as you guys know, that's a case we definitely want to take. What do you do to start preparing that case for what a jury's going to think?
Well, we start from the very enviable position of having clear liability, right? And it was interesting that the defense made the strategic decision to deny liability until the day we showed up for trial. And on that date, they said, we want to stipulate as to liability, and we want to take away the plaintiff's right to discuss the accident, the modality of the injury. We admit it was our fault. And I think that somewhat coincides with what the point John was making, that they wanted to make this a medical causation case. Unfortunately, they were unfamiliar with Georgia case law that states that the pleadings, whether they're introduced into evidence within the state of Georgia, you can still talk about them. And so the judge allowed us to present our entire case because there was an attempt to sandbag us at trial. And I think that is something that resonated with the jury. I mean, it's an age-old adage that, that the defense wanted to deny liability until they're faced with the prospect of having to answer to you as jurors.
They were denying liability as far as a pretrial order.
You're off the screen.
They were denying liability as far as a pretrial order and the pretrial conference, which was not more than a month or so before.
So that had to piss the judge off.
They picked the wrong judge. Judge Gordon's a great judge. She's a former district attorney. She believes things should be black and white. She believes there should be no sandbagging. And when they announced at 9 a.m. they want to stipulate to liability, when our expert's already on a plane from Pennsylvania. She was already on a plane from Pennsylvania. Putting the case law aside, it just struck her nerve as this is a attempt to disadvantage the plaintiffs. And so she wanted no part of it. So now the plaintiffs get to present whatever they want.
So one tip I think our listeners should really take from that is, before you go to trial, understand the case law, what happens if there's going to be a stipulation of liability, when it's appropriate, and what you can and can't do for trial. Because if someone a little bit lesser than you guys gets hit with that, they may just panic and not know what to argue.
I have to give a shout out here, because as it was happening, we were doing just very quick research, and I picked up the phone and called Lance Laurie and said, Lance, have you had this happen? He goes, oh, no, you can't do that. There are these cases. And Lance shot us those cases very quickly. And it really says a lot about the community and the fact that, people do long-term care work. It's a calling. And it's us against them to benefit our senior citizens. And it's a prime example of how we work together. And so,
I guess people who do nursing home work will agree with that. I mean, it is in other types of fields, it's us against us, right? You have two plaintiff lawyers and they may not want to help you because they didn't get the case. In nursing home world, I mean, you and I have helped each other, and we don't practice in the same states. And we would just shoot things back and forth. Lance, there is something to be said about the nursing home lawyers of the country.
And I think that's exemplified in our listserv. I mean, what an incredible wealth of knowledge from the entire country, and the ability to reach out to California and see what's happening. Let's see what's happening in Chicago. How are people addressing this? I mean, look at the conversations that people are having on how to approach the COVID crisis and whether or not the COVID cases will be viable claims. And the discussion that people are having, the points that people are making, is invaluable.
Yeah, it really is. I want to take us back to a minute. So now we've got this case that if John was still the defense lawyer, and John, am I right? At one point before you teamed up with Mike and Bill, you defended med mal cases.
15 years, primarily med mal, defending hospitals and doctors.
So if you had an elderly person who's not quite sure where she is, in hospice, dropped maybe, had a brain bleed that got better and then she died of something else, you would be licking your chops with regard to causal relationship.
We'd offer 50, 60 grand and say, all right.
So why don't you guys tell me before, just so everybody understands, before we get to the trial, you're going to do discovery. What are you doing to try to take that defense away of causation in a case like this?
Family, 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 and family.
Okay.
These kids, they're not kids, they were grown men. These men were credible. They were there every day. They were able to testify about how their mother would groan out in sheer pain after the event occurred. And, they were also able to, I guess, testify as to the fact that she remained in pain until the day that she died. And when you tell the story, not just of what occurred at a nursing home, because the story starts long before. I mean, when we present cases, we present a testament to our client's life. It's important that the jury know who this person was, that they feel that they have something in common with these folks, that they are good people who tried to live right, do the right thing. And I think that if you lay a proper foundation in fact and show that the family is credible, then if there's a toss-up, you win that toss-up.
Okay.
Also, we're fortunate to have a very good medical examiner that gave us enough ammunition medically to get to the jury in that issue. He did opine that it played a role in her death. And with all these cases, we never take the case, or we never take the position that she's going to live 5 or 10 years longer. We say, we don't know how long it would have been, but it would not have been that day. And we let you, the jury, if it's the next day she would have passed, next week, next month, next year, nobody knows. And so along with the family's moving testimony about how she reacted, and then the medical examiner getting us to the jury, in which we knew would go to the jury, that got us there. And then without spoiling the ending, sometimes the jury might give a compromise, and even if you don't get the wrongful death, they'll award you for the pain and suffering. We just want to get to the jury in that point.
Yeah, I think a lot of times, I mean, as important as the jury charges are, and they're incredibly important of what you have to prove, every time, at least in New Jersey, our wrongful death statute, you only got pecuniary loss. The money you were getting from the loved one who was in the nursing home, which is rarely $1. It's more often than not, they're paying for mom to be in the nursing home. And when defense lawyers used to say, well, the death doesn't really matter because you don't get any damages, my answer to that always was, I think you should make that argument to the jury.
Absolutely.
Yeah, I think, you should say to the jury, look, we feel bad that she died, but that has no value. I said, let's see what they say. Because you're right. They may not give you anything on wrongful death, but they may double the compensatory damages just to spite them.
So absolutely. And, I think the one thing that I've yet to mention is the one staple of all nursing home cases. And that is, we all understand that people that are there are sick, but everyone has a right to live and to die with dignity. And they took away her right to die with dignity. I mean, everyone's going to die, and it would be wonderful if everyone died with their family members, around their bed, holding hands, but that's not always the case. Sometimes, for no one's fault, death can be very ugly. But here we had a lady who was declining without question, and she spent the last month of her life in severe pain that did not have to happen, but for the reckless disregard of the facility and an intentional decision to understaff, right? And so the dignity, you lay the foundation of a dignified existence from the first words out of your mouth until the end of your closing. It's dignity, 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 because everyone wants a dignified existence for themselves, and they certainly want it for the people that they love who may be in a skilled nursing facility.
Absolutely. One of the things I used to do in every wrongful death case, although we were very limited in our voir dire in New Jersey, one of the questions we would submit to the court, and it was given every time but once, is some people think that we're all going to die. And It doesn't really matter when or how, because it's going to happen to everyone. What do you think? Does it matter how you die? And you would get the weirdest answers, because they would look at you as if you were crazy, because of course it matters how you die. And they would say that. And later on in the closing argument, I would try to take the responses from those jurors that they gave us in voir dire and use them as my argument. Remember what we all said, 7 days ago. Of course it matters how you die. You all looked at me with a weird face, like, what kind of question is that? Well, that's what the defense is telling you, that it doesn't matter how you die. And this is your chance to say, yes, it does, and kind of bring those together for that reason, and then bring in dignity, because I think it's pretty important.
So that exemplifies why you were a successful trial lawyer. That is a great argument. I really like that. I like that a lot.
I'd like to say I thought of that before this podcast, but I didn't.
I am confident I did not think of it. I don't believe I thought of anything, and I actually think that's Ken Connors, which is why it's so good.
Yes.
Well, we're going to steal it no matter who it's from.
It becomes really powerful when you're looking at jurors, especially if they gave you that quizzical look when you ask them the question in voir dire, as if, what are you, an idiot? Of course it matters. When you're turning that and giving it right back to them, and then using that to empower them to say to the defendant, it does matter how you die, that's a game changer, I think, or it can be a game changer. So something I didn't hear from you guys yet that I want to talk about is we've got the family, and here you have a great family. You've got a defense attorney who's maybe playing some games that may come out in front of the jury, even if you don't say it when you're reading different documents. What about?
We said it. Trust me.
Oh, okay.
We said it a lot. Every chance we got.
And the judge let us.
And the judge let us.
Actually, I want to ask you before I get to the next question, Mike. You have a quote that you love that I believe John and Bill do not love about responsibility. If memory serves.
You're absolutely correct.
Share with me the quote.
So it's really more of a story, and the story is that responsibility is not one word; it's really two words. Everyone has abilities, and the question is, what will your response to your abilities be? And so we use that in closing argument to empower the jury to say, used as an example, you had the ability to make up answers that you didn't mean to get out to avoid jury service. You had the ability to not show up today. You have lots of different abilities. And here you had the ability to pay attention, to listen to the evidence that was before you, and what will your response to your ability be? And we ended by saying, we hope that you will fulfill your responsibility by giving justice to the family. And I think it resonated with the jury, despite what my law partners believed.
And I can tell you, after I was up there with you guys, and I think I went to Ohio like 3 weeks later. We're going back a couple of years now. I focus group that. And I focus group that 3 times. Everybody loves it, John. I'm just letting you know. But really, that's responsibility. It's not just what you did, it's what you did in response to what happened and what your abilities are. So it was very interesting.
I might get sea bass, I might get bronzino. They're still good fish. We're still having a good meal.
So getting back to the defendant is, tell me about the discovery you did before we get to the trial to find out who the defendant is, what they did and what they didn't do, which caused this fall.
Well, that's an interesting question, because 18 months later, we're still battling them because they played the corporate shell game, and we're trying to find the money. So when you say the discovery, who did what, it was pretty quickly identified who the provider was that rolled the patient. That was easy enough to do. And I'm going to give Evan credit again. He took the initial discovery deposition of their geriatrician expert, and he actually prepared slides that had him check like agree or disagree. It was something as a defense lawyer I would never have allowed, but the defense lawyer didn't. And Evan asked him 8 or 9 straight up standard of care questions. This violated the standard of care, and this shouldn't have happened, and this caused injury. And for the most part, the expert agreed with what we wanted him to agree with. So that just made us so perplexed as to why they did not accept liability any sooner. We had talked as defense lawyers, the best defense for this case is to humbly admit to the jury, you caused the injury, you were very apologetic, you immediately disciplined, if not fired, the employee, and we're here to discuss what would be an appropriate amount that's fair to both sides. We think that would have tempered any anger that the jury might have, but their strategy backfired, and even though it wasn't a punitive damage case per se, by pulling the stunts and by the jury understanding that up until 48 hours early they had admitted liability, that anger that they should have quelled with an early admission of liability backfired in them, resulting in a good side verdict.
So you said that's a shell game, which is every nursing home case. Now it may not be a high asset shell game, but I've yet to have a nursing home case in 30 years that didn't involve 4 LLCs, 5 LLCs. Sometimes their names are the same, but in this case, from what you're telling me, is it looked like it was really a shell game where they were claiming they weren't related and hiding assets?
Well, yet again, team effort. We have to give a shout out to Ernie Tosh, who did an evaluation for us. Ernie does.
And for the listeners, Ernest Tosh is a lawyer from Texas who has developed a system where he gets the cost reports from the state, from the federal government, and is able to determine where the money goes with every particular nursing home.
Absolutely. He can also look to determine whether or not they exceed the standard reimbursement rates for affiliated entities. He can see whether they have, whether or not they exceed what CMS would anticipate for rehab days, or whether their RUB scores were abnormally high, and the staffing. So he can help you. It shortcuts hundreds of hours worth of work in developing your case by engaging Ernie. I mean, it's just an invaluable tool.
I call him our Swiss Army knife expert because he can do 4 or 5 things equally good for you that all are helpful.
And the beauty of those reports that you get from him are, whether they're admissible or not or irrelevant, I don't think they're discoverable. And it tells you which path you should be traveling in discovery. And then you have information that there's no way the defense lawyer is aware of.
That's right.
And in this case, we never really made staffing a big issue, but as Mike said, he was able to show how much money was going to related parties, which is an issue in just about every case.
Which I know that when John said that, you shivered about staffing being an issue. There were some ancillary issues that were ongoing. I was getting ready for a deployment, being in the reserves to go to Iraq, and we asked the court to expedite the discovery track and to allow us to get our trial specially set, and she did. And so it was the Wild West getting this stuff done. And so we had to make tactical decisions regarding whether or not we wanted to keep this narrow in scope or whether or not we wanted to expand it. I understand that the traditional thought is that you expand everything into the corporate malfeasance aspect and the specific intent to understaff for corporate profit. In this case, we really didn't focus as much on that issue because we had what we thought was a clear liability claim. We had a wonderful family, and in all candor, it helped us set values as to what these cases would be worth from a resolution perspective, without having to go to trial. So we were trying to reset the bar.
Right.
If that makes sense.
And in the face of a defendant claiming a $250,000 eroding policy. So there was always issues about collection and how much should we put in, how much is responsible when we realize there may be limited funds for the client.
And I think that's an issue that's in every nursing home case, right? I mean, I work on cases all over the country, as you guys know, and in certain cap states, lawyers say to me, well, I think it's great that you've come up with all this stuff that we should do, but we have a $500,000 cap. We really don't want to spend all the money to do that. And what I've always explained to them is all we need are some issues that will allow the jury to make decisions on their own. All we need are a couple facts. We don't have to prove all this wild understaffing. They've made $1 million a year saving money by understaffing. A lot of times you don't have to get it that far other than to show some through anecdotal evidence. There was nobody ever at the nursing station.
Well, and so to add to that, and this is the med mal side of me, I would say, obviously, you're going to strategically change your plan case by case basis. But for medicine, for a medical case, certainly the simpler the better. And this was the case. We ultimately thought simpler the better. We had at one point, we had a laundry list of faults. And we thought maybe we should bring that in. And a focus group told us to the contrary, don't bring it in because now they're going to be critical of the brothers for leaving her in a place where there were a number of faults. And so we turned this, what could have been a 8-9 prong attack, into you dumped her on her head and you shouldn't have. And we made it simple.
I think that's brilliant, John, because I have to tell you, a lot of lawyers don't have the ability to do that. If they think there's 30 things that this facility did wrong, they want to talk about 30 things in the case. And I'm with you. I pick my 3 best things, and that's what I go with. Maybe you go to 5, but
it's good to defend 10 things because 4 or 5 of those things you're defending, you're going to have a really good defense to. And so you seem to have more credibility as a defense attorney when you're actually rebutting something that should be rebutted, and therefore it makes the 2 or 3 good points of the plaintiff weaker. If there's only one thing saying you shouldn't have rolled this lady to her bed where she developed a welt the size of a basketball, it's tough for them to talk about anything other than that, and they really lose credibility if they try to defend that at all.
I mean, I've always said that, there should be 3 to 5 documents that you use throughout the entire trial, to the point where when you say to whomever you're working with or to a witness, can you take a look at P35? The jury, by the time you're on the second day of trial, knows what P35 is and knows what it's going to mean and what it's going to say. And then if somebody says something different, they're taken aback, as if that witness must not know what they're talking about. And that's the same issue as just 1 fall or 2 falls. If you're going to talk about the 3 times they didn't feed her on time, and you're going to talk about the fact that she lost 4 pounds and how horrible that was, now you're whining. Now you're taking all the steam out of your case. I love that. I love that you guys did that.
Yeah, you dilute your arguments. You did.
So now it's clear they've got, so now not only do you guys have the shell game, but you have an eroding policy. So, and they're still not offering you the remainder of the policy.
No, the policy's long gone.
It gets more complicated than that.
For us, we did have a successful verdict, and we served discovery immediately after the verdict. They filed a motion for a new trial, which one would anticipate. And in Georgia, that stays their obligation or tolls their obligation to respond to discovery. And then they asked to wait until they had a full transcript before they could prepare their motion. And that was a 6-month delay, I believe. I think it was a 6-month delay. And
May 1st to October 30th.
Yeah, there you go. So
to the hearing.
So then they filed their motion for a new trial, and we show up for a hearing. When we show up for a hearing, they withdraw their motion for a new trial. So we're scratching our head and we're like, what the heck is going on? Well, as we sit here now, it's pretty obvious what was going on. They had signed a contract to sell the facility to what we believe is an affiliated entity for, it had an $800,000 accounts receivable, all of their equipment, all of their supplies, for $10 and other good consideration. Am I misstating that, John?
Well, so there was two players.
Yeah.
The entity we got the verdict against, they operated and managed the business. So their business,
So the licensee.
they're the licensee.
Licensee.
Not receivable. What happened was, unbeknownst to us, because we got our verdict on April 25th. We didn't get their post-judgment responses to December 2nd. So that's the 6-7 months Mike was talking about. So for 7 months, we had no idea this was going on. But in the interim, as of May 31st, the defendant sold all of its assets to what we believe is a related company, and an affiliated company sold the actual land in the building as well. And what they did, just to show what a ploy it was, everything was sucked up into one sale for the non-defendant. So even when we sent a second set of interrogatories to the defendant saying, all right, well, what did you sell it for? Tell us. They said, oh, no, it was part of a larger transaction. So we don't even have documentation. We just had a somewhat angry judge last week rule in our favor in a motion to compel, telling them that you need to produce everything you've got to show where that money went. Because as Mike said, in the 6 months that we were just sitting in limbo, $800,000 in Medicare and Medicaid receivables came in and went out, and we didn't even know it. So we weren't able to garnish it.
And people who are listening to this say they want to do nursing homework.
Yeah.
So, but I got to tell you, this has invigorated the Cuban and the Italian anger in us, and so this is going to be fun tracking it down.
Have you guys done any or thought about filing a motion to set aside the sale, that it was a fraudulent transaction?
That's what we're laying the groundwork for.
Oh, okay.
Here's the corporate veil, and then your listeners will find this interesting too. Literally September 25th, which would have been 17 months after the verdict, defense counsel called us and said they had found a policy for $1 million, but they thought it was a Scrivener's error, so it was never produced. They don't think it applies. The judge was not happy with that either. So we also have the possibility of filing a deck action in federal court. Yep.
Yes. So for people who are listening to this, my mouth is agape.
Yeah.
One of the things we do, and I know the three of us have discussed this, and this is one of the reasons why we do it, is we do that 30B6 dep in the beginning for the records, where we go through everything, where it is, where it would be. It wouldn't change anything that happened, but it may provide more information, but you're going to do it now, so it almost doesn't matter. But this is why we as nursing home lawyers really don't like nursing homes, or I should say don't like owners of nursing homes. And it's one of the reasons why I think it's not a good idea to sue the nurses, or to make the nurses and the CNAs the devil or evil, that they did something wrong, because they're put in a position by the owners of many of these nursing homes to fail, right?
Absolutely. And I'll tell you that unlike many of our peers, I actually worked in a nursing home. I worked in a nursing home as a CNA when I was in college, and it was a 100% Medicaid facility. It was the first African-American nursing home ever created in the state of Georgia.
Oh, wow.
And it was the hardest work I had ever done in my life. I've spent 30 years in the military. I've had some pretty bad jobs. It was by far the most difficult. And there were some really, really, really special people who worked there. So,
well, it's just fascinating to me. I agree. I mean, I just did we have a YouTube channel where we have a trial tip of the week and a nursing home minute of the week. And since both of you are my friends, you still don't know that. That makes me feel really good. And one of the ones we just dropped was deposing the CNA. And it talks about that more often than not, the CNA is the best witness in the case, because they were devastated when your client died because they cared for them.
Absolutely. And, I met some wonderful people, and I eventually, as I became a lawyer, sued that nursing home and put them out of business. And we took our entire file to the district attorney, who referred us to the U.S. attorney, and that owner is now in prison for elder abuse, where he will spend the remainder of his life.
So
Karma.
I think that goes again to like what you were saying. Suing nursing homes is a calling. It's not personal injury. It's not medical malpractice. It's a way of life. It definitely is. So now you're armed with, if I get it, you're getting ready to try the case. You've got multiple falls, which you're kind of ignoring. You still have that same causation issue. And now you're armed with a facility that's shady in its numbers, probably understaffing, but you know that it's going to be too hard and too expensive to prove that economically and through numbers. So you've got to do it anecdotally. Is that about where we are?
Absolutely.
So now the trial's a week away. What are you guys doing?
We focus group with a guy named Saul Gruber and get some really good information.
I think I know him. Short guy.
No, I mean, so the information that you gave us was very, very valuable. And we certainly incorporated that into our trial. And it helped us condense this because, as John said, we wanted to make this a very simple case. This was about a family, a drop, and an agonizing death. Those were our three things. You said three things. Those were our three things. And those are the 3 points that we developed when working with you. And, you know, like many defense lawyers, the defense lawyer in this case could not help himself by attempting to attack the family. And it was a horrible, horrible tactical decision for him to make. And it backfired terribly. And, you know, it is certainly something that we pointed out in closing argument. And when we were able to speak to the jurors afterwards, they all said that it offended them greatly. So it was a good thing. With respect to the trial went pretty smoothly. I don't think there were many objections whatsoever. The case had been worked up well. It was a firm that we litigate against often. It was a lead counsel that I'd tried a case against before. So we kind of knew what people were going to do. And so it went pretty smoothly. The defense lawyer did again make a tactical error by suggesting a number that I felt was insulting, and I certainly let the jury know that it was insulting. I think they found it was insulting. Interestingly, despite all of our evidence from a forensic pathologist regarding whether or not the drop contributed to the death, because in Georgia, it can be caused or contributed to the death, we now know that it was a compromised verdict because we lost the wrongful death claim, but the jury made a significant award for the estate. And so we thought it would be the other way around because she wasn't conscious a lot. But the verdict was 1-8, and with prejudgment interest, it was 2, and I think it's probably 2-2 or 2-3 right now.
And just growing every day.
And rolling every day. So now, what they don't understand is what John referenced is we won't quit. We're never going to let go, and we will chase them to the ends of the earth to make sure that Miss Mitchell's legacy is honored by them paying what they owe.
I'm curious. Let's get back to, because I know there's going to be a lot of people listening to this who don't handle these cases, or even who do handle these cases, and say, how could you possibly get that much money based on what you told us? Was there any anchors that you used, either financially or emotionally, during the trial? So, all right. I'm hesitant to tell you my anchor. So, and I'm not a baseball guy. John is. So, John, who's the baseball player?
We referenced Mike Trout's $465 million contractors, or maybe 435. I forgot what.
So tell me how you did that, John.
I fed Mike. No, we broke it down into what the contract was worth per year, per game, per inning, 4 at-bats, how many putouts, and then we came up with some obscene number every time we went to the plate, whatever that number was, or every time we had to put out whatever that number was. And Mike appropriately touched on it, but that wasn't the focus of the argument. But it was kind of a, by the way, this is how society values just athletic ability, and touched and then left it. Not to not to have the entire argument based on that, because everyone knows what's a Monet worth, what's a Rembrandt worth,
Sure.
what's that
And
worth.
in your closing argument, who did the closing?
I did.
So, Mike, in your closing arguments, I mean, when you talk about value, right, which is different to all of us, is that where you weave in the different paintings, what we all value in society, and look at Mike Trout's salary?
Yeah, I did. I mean, in essence, what I said, Saul, was that if, as a society, if we place that much value on an athlete's ability to catch a ball or to swing a stick, then certainly we should hold the sanctity of life in equal or more value. I mean, when you consider how many hours a week a professional baseball player actually plays and the value that they derive from that, then certainly a son's ability to spend time with their mother and their mother's ability to spend time with their son has got to hold an equal value. And, for the folks that listen to country music, there's a song that Tim McGraw did about live like you were dying. And when is life more valuable? Is it more valuable to you? Because in Georgia, the measure of a wrongful death claim is the full value of a life as seen through the eyes of the decedent. So when is life more precious to you? When you're 18 and you think you've got the rest of the world, you've got infinity, or when you know you're sick and you know that the end is near, that is the most precious time we ever have with our loved ones. And so a jury has to put significant value on that.
I mean, that's a great argument, obviously. When you're making that argument, you're looking at the jury. What type of jury did you have? Because that argument may fall flat with millennials they may fall flat with millennials, but it may really resonate with someone who's 63.
It may. We had 7 women, 5 men. It was
Equal, 7 Caucasians, 5 minorities.
Yeah. The racial makeup was, I think, 7 Caucasians, and the average age was probably in the 40s up. We didn't have a lot of young kids there. We had the one young kid who was a computer programmer who was not terribly friendly towards us. During deliberations, we found. I think it exemplifies your point. You have to know your jury.
Yeah.
I think that some things just traditionally, and family has got to be one of the things that everyone values, and your ability to spend time with your mother, your father, your grandmother, your aunt and uncle. Those are intangibles that really don't have a price tag. So maybe I need to learn to speak millennial a little bit better and come up with a mathematical equation.
Well, I would love to give you advice on that, but we've done complete millennial focus groups. They're not good. And not only are they not good, they just don't really give us any information that would resonate with us. It's just not been good. Like, I did a focus group with Evan in Atlanta, and Evan was texting me every 7 seconds. Get their love language, and I would text them back saying, I don't know what you're asking me. And then I realized what he means is, because there were a lot of conservatives on the focus group panel, is what do they respond to? What do they want to hear? And we were really able to do a lot. I think that case settled that Evan had, but we were able to do a lot with that in asking them questions and finding the information. Every time we've done that with a millennial, I just get a shrug. It's just it's disconcerting is what it is.
I think if we put on Snapchat, we'd be okay.
Yeah, well, that's exactly right.
They would actually pay attention to it.
Which is why we were talking earlier. I still stand by the proposition that when you open in front of a jury, you almost need to grab them with one of the most important points of your case in the first minute and a half, or you may lose them forever. And that's definitely the case with millennials.
Well, in all candor, if we had a very young jury, I think we need to step up our use of technology. I mean, when you have an older jury, you might be able to get an old flip pad and make notes on it, which I think in the more rural jurisdictions may be a very valuable tool because you don't come across as being slick.
Right.
But in a metro area with millennials, I could see us using a tremendous amount of technology and PowerPoints because the attention span is so much lower and they're used to technology.
Which is why I tell everybody, just focus group the case where it's being tried. Not for value, because who knows what value is really, but just for what's their thought. Have they heard of the nursing home? What do they think of the nursing home? You can even do that through surveys. And like you said, do you want to see something on an iPad that creates a hologram in front of you, or do you want to see something on a flip pad? I actually think it's important. So John, we've got a $1.8 million verdict. You're the former defense lawyer who was always worried about causal relationship. We've already discussed the case. What do you think the reason the jury gave that verdict was at trial?
I think they were all.
Other than the closing argument.
Obviously we have to take that out.
I was going to add in spite of the closing argument. I think they all realized the nursing home had done wrong. I think they were upset with the nursing home and how it was handled by the nursing home up to and even at trial. And I think there were one or two folks, though, that were kind of in the defense minded, like I have been. Yeah, but there's still not a whole lot of injury when you consider the age, the comorbidities, et cetera. So I think it was a compromise verdict. And was it one, or it may have been 2, 3 at most, but I think we had 10 pretty much in our camp. So I think just to appease the defense-minded folks, they said, tell you what, we'll say it didn't cause a death, but we're going to load up on compensatory. And as Mike said, 1.8 we were a little bit surprised. For our cardiologist, the judge starts with the wrongful death first. So when he said, as far as the wrongful death, we find in favor of the defendant, there were some anxious moments. We were waiting to hear what was coming next.
Yeah.
Oh, yeah, that. And I think those of us who try cases know that period of time where the judge says the jury has a verdict and the end of the jury reading the verdict may be the worst, 10 minutes.
It's agonizing.
It's horrific. It's unless you've been through it, you can't imagine how agonizing it is. So John, what I'm hearing from you is you think the key to the case was the actions of the defendant and the failure to take responsibility until it would benefit them to take responsibility, and that just pissed the jury off.
I don't know if that was the whole thing, but I think that was a big part of it. Their expert, I thought, was a little too glib for his own good, and their expert in trying to show about how unresponsive Our Lady was, they actually had their expert be critical of their own nurse who had documented in the record hours before the fall that she was alert and oriented and responsive and that type of thing. And so the expert to support his position that this was a life not worth really reimbursing, he actually said, well, I don't think their own nurse knew how to take vital signs.
Yeah.
And so we actually led him through a very brief, all right, what's your name, just to get her cognition. What's your name? What are you doing? Where are you from? What time is it? And we said, that's not so hard. So their own expert had to criticize the very nurse that we were already critical of. And quite frankly, Mike may disagree. I thought the nurse did a pretty good job as being a nice lady, a credible lady who just made a really bad mistake on one day.
And it was interesting. We actually made a tactical decision not to bring in the CNA who had rolled her out of bed.
Well, I'm sorry, I was talking about the supervisor.
Yeah.
Supervisor was nice.
No, the supervisor was very nice. She was very credible.
What led to that decision?
She was wonderful. She was wonderful. I met with her. She was a former employee. She was very credible. She was very conscientious about what had occurred. She was heartbroken over it. And we would have greatly preferred to vilify her from afar than to present her to the jury.
Why didn't the defense bring her in?
Because
I think they were scared of what she was going to say. I don't know that they had established contact with her.
They did establish contact with her, but also found out that she had been speaking to me, and they were very concerned about allegations of staffing.
Got it.
Our thought is the records make very clear what happened. Why have somebody up there just to reaffirm what happened at the prospect of her looking better and it becoming a less dastardly deed?
Which again leads us to another tip that I keep giving that people ignore is every witness and every question has to propel your story the right way. And if it doesn't propel your story, just don't use it.
I agree.
Agreed.
You'd be shocked at how many lawyers don't agree with that. Who,
you know, another issue that I think we all face as trial lawyers today is that I call it the law and order syndrome. I mean, in Law and Order, the series on television, there's a crime that's committed, an investigation, a full-fledged trial within an hour.
yeah,
And so we as trial lawyers want to be incredibly thorough, and we can, so to say, beat the dead horse when jurors want brevity. Yes, we get that fact. Let's move on. What's next? So there's a balancing act that one has to consider when calling witnesses that are needless.
we did a podcast with Tad Thomas. I know you guys know Tad. And Tad tried a case, got a similar verdict in Paducah, Kentucky. I mean, it's Paducah. So, you know, it's a small conservative town. And the judge gave him 3 days to try his case and the defense 2 days to try their case. Okay. And they each had 2 experts. So Tad said they had to work really hard to really sharpen their case, to only put in what was necessary. And the same thing with their cross-examinations. And he believes that that's why they got such a good verdict, is because they were to the point, they made their point, the jury got it, and they respected the jury and moved to the next issue.
I think that's smart. I mean, I think we were done in 5 days, weren't we?
We actually got a verdict on Thursday.
Yeah, on Thursday. So started on Monday, got a verdict on Thursday.
Well, I think that's the key for plaintiffs. When we go into those 2 and 3 week trials, because we just go off on tangents, that only hurts us. That doesn't hurt the defense.
You lose the jury.
You do.
You lose the jury.
So Mike,
trials are better for the defense than the plaintiff.
Oh yeah. So Mike, let me ask you this question. One thing that you think turned the jury into this verdict, what do you think it was? Other than your closing argument, of course.
For me, I thought it was the fact that we had a very genuine family and that the sons were heartbroken, not so much that they lost their mother, but at how they lost their mother.
And if I'm correct, they're the questions that you have to do at trial. What happened? How it happened? I normally add why it happened.
Yeah.
Did you get into the why, or was that what you kind of pulled off of in this case?
And to be honest with you, it was a very, I guess, partly debate on our side. And Jon was the prevailing thought of let's keep it out. And it was very smart. It worked.
Okay. Michael, Jon, thank you very much. I appreciate you coming out and talking about the trial, and more importantly, telling us some really good stories that we can take into our own cases. And I will hopefully see you guys very soon.
Thanks, Saul.
Thanks.
Appreciate it.
Well, once again, this is The Jury Thinks What, and I am Saul Gruber from Gruber Trial Consulting, your host. That was such a great interview with both Jon Marigliano and Mike Prieto, really talking about trying a nursing home case, not only the case they tried, but also the thought process that goes into trying these cases. I don't think a lot of lawyers who do not do this really understand what a nursing home case really is, how complicated it can be, and how much of a calling it really is. And I can't thank those guys enough. The tips they gave us were so many and were quite dramatic, which leads me into my nursing home tip of the week. And really, this whole podcast was a nursing home tip of the week. But as something that we talked about a little bit in during the interview, it's something that David Hoey once said to me. David is a good friend and a Boston lawyer handling nursing home cases all over the country. You need 3 things to take a nursing home case: a really good family, a really bad facility, and either an egregious act or an egregious injury. And normally when you violate those three things and take one without one of them, it normally hurts the case. But you heard what Mike and John said. They really felt that the key to their case was how good and close the family was. So again, the jury thinks what? This is Saul Gruber from Gruber Trial Consulting. If you are watching this and have not yet subscribed to the podcast, you can do so anywhere podcasts are available, whether it be Spotify or Apple. Also, please go to Gruber Trial Consulting's YouTube page, where you can get weekly nursing home minutes and trial tips by subscribing. And thanks again, and see you next time. Bye.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.